Thank you for that guidance, Mr. Speaker, sir.
And my apologies. Your time's just running from now.
Thank you. Thank you, Mr. Speaker, sir, for the opportunity. Like indicated earlier, we have raised a PO, the one dated 29th of November 2025, and contains in the governor's documents at volume 1. It's a very thin document, volume 1 of the governor's documents. A very thin document, Mr. Speaker, sir. Mr. Speaker, sir, the objection that we have raised through this PO is not just about a procedural issue. It boils down to the very core and principles of our Constitution, because the motion that has been presented before you and the resolutions by the County Assembly of NYAMIRA do not meet the legal threshold. At the end of my presentation, honorable senators, you will have no doubt in your mind that the motion before you is based on a foundation that is constitutionally rotten, procedurally fraudulent, and mathematically impossible. I will be submitting that there is only one remedy available for this kind of an incompetent motion, and that is to terminate it before moving for trial. For allowing the procedure to go on to full trial would be to let a nullity in law assume cloak of legitimacy. Mr. Speaker, sir, the core of our objection is that the motion before you does not mean the 2/3 threshold that has been set by our Constitution and the other enabling provisions of the law. This ground is premised on two main issues. If the impeachment proceedings were to succeed, then it must have been supported by at least 2/3 of all the members of the County Assembly. And therefore, honorable senators, before even interrogating the issues before you, the first call of duty is for you to satisfy yourself that the resolution that has been forwarded by the County Assembly meets that threshold. Honorable senators, there are only 3 legal provisions that guide on matters impeachment. One is Article 181 of the Constitution, which requires that the County Assembly, through the operationalization of Section 33, must meet that threshold. And when you look at Section 33 of the County Governments Act, it provides as follows. One is that, but before I go there, honorable senators, let me submit as follows. Matters impeachment must begin from Article 181. Article 181 gave Parliament the power to enact a law that provides for the procedure of removing a governor from office. Pursuant to that mandate, this Parliament enacted Section 33 of the County Governments Act. The provisions of Article 33 are very clear that the threshold must be 2/3 of all the members of the County Assembly. Now, the County Assembly will appear before you and argue that the threshold had been reduced by vacancies that had resulted from death, designation, or other factors. But, honorable senators, the constitutional threshold remains fixed. It cannot be altered. It cannot be amended. And therefore, honorable senators, what is the total number of the County Assembly of NYAMIRA? At volume 2A of the governor's document, you will come across the official determination of the total number of members of the County Assembly of NYAMIRA. Honorable Senators, who makes a determination on the total number of members of the County Assembly? It is not the Speaker of the County Assembly. It is not the Leader of Majority. It is not the mover of the motion. It is not any member of the County Assembly. That determination on the total number of the members of County Assembly is predetermined by the very institution that has been mandated with matters election in Kenya, and that is IEBC. At page 42 all the way to page 46 of volume 2A of the governor's documents, you will come across a gazette notice that was published way back in 2022, confirming the total number of members of the County Assembly of NYAMIRA. So that is the total number, legally declared, legally fixed, that cannot be changed or altered by any member. That number, Honorable Senators, is 35. 20 elected members of the County Assembly, 11 members as gender top-up, and 4 representing the marginalized. That is the position. That is the legal position. It has never changed at any given moment. So we have no doubt in our minds that the County Assembly of NYAMIRA has a total of 35 members of the County Assembly. That number cannot be reduced by interpretation, by innovation, or by improvising of any member. So, having that in mind then, Honorable Senators, what is the 2/3 of 35? I may not be very good in maths, but we've been here before with the Kericho matter, with the Isiolo matter, and this Senate was very clear that you cannot have half a person. And therefore, when I do my maths correctly, is that at least 2/3 of 35 must remain to be 24. So the question then that this Senate will have to ask itself is whether 24 members of the County Assembly resolved to impeach the governor. Should you find that you do not have 24 people who voted in favor of this motion, there is only one remedy: to send the County Assembly back to the drawing board for them to meet that threshold. Honorable Senators, the record before you will demonstrate 2 things. One is that there were 19 members present on 25th of November 2025 that voted to impeach the governor. That is on record. The Hansard speak for itself. 19 members. However, strangely, Honorable Senators, 23 votes were generated from a total of 19 members who are present in chambers. Section 20 of the County Governments Act gives directions on the procedure of voting. And it says as follows, that any decision of the County Assembly shall be made by members present and voting. That is Section 20. By members present and voting. Their own standing orders, standing order number 67, speaks verbatim Section 20 and says that any decision of the County Assembly shall be made by members present and voting. Now, if we only had 19 members in chambers, they have given you that list. How could they generate more than 19 votes? Honorable Senators, it's a joke of the year. I may not be good in maths, but I am sure that a total of 19 will never generate 23. On that ground alone, Honorable Senators, this is a flawed motion. It cannot be entertained. I know my learned friends will come here and try to persuade you to proceed to full trial to make a determination. The question is, what will you be calling witnesses to confirm or to adduce evidence on? Their own numbers confirm that they had 19 people, but 23 votes were cast. And what is the explanation they are giving? That there was voting by proxy. I went looking through our constitution, the County Governments Act, their own standing orders. There is nothing that is known as proxy voting. So what is this concept that is being introduced? Voting by proxy. Honorable Senators, the mandate of a legislator in a county assembly or in Senate such as this is delegated by Mwananchi. You cannot delegate that mandate further by giving someone else that mandate to vote on your behalf. They will produce letters that, incidentally, Honorable Senators, and this is very important, those letters were never tabled on 25th of November 2025 before the floor of the County Assembly. Those letters were not forwarded at the beginning when this resolution was forwarded to Senate. Those letters only emerged on 1st of December 2025 when now they were presenting their second set of documents. Honorable Senators, what is this voting by proxy? Section 20, and I repeat because this is very important, it says, unless otherwise provided by the Constitution, written law, or any other law, voting shall be by members present and voting. Decisions shall be by members present and voting. I dare the County Assembly to give us evidence of where voting by proxy has been provided elsewhere, either in the Constitution, the County Government Act, or their own standing orders. There is none. So where the law is clear on the procedure, you cannot innovate, you cannot improvise, you cannot interpret it to suit your illegal intentions. But assuming for a moment, Honorable Senators, that even voting by proxy is allowed, was there then voting by proxy? Before you, Honorable Senators, are affidavits by the 4 members that are said to have given instructions to vote. One of them in her affidavit that she is not even in Kenya. She is in Kansas, United States of America. On the very day, she had not seen the motion, she had not read the contents, she had no idea that this was happening. Yet someone purports to have gotten instruction on her behalf to vote. We have Julius Obonyo, we have Elijah Sagwe, Priscilla Nachichi. They have all sworn affidavits stating that they were in Mombasa on 25th when this motion was being passed. They have sworn under oath that they did not give anyone instructions to vote on their behalf, assuming even proxy voting was allowed. This is a clear case of not just fraudulent misrepresentation and forgery, but it's an issue that this Senate should take seriously and recommend criminal charges against the perpetrators of this heinous act. There was a reason why the enactors of our Constitution demanded that decision must be made by members present and voting. Your own standing orders, Honorable Senators, and I've been here before. There are 2 ways of being present and voting. Either you're physically present in chambers where bars are drawn, or you appear virtually. And even as you appear virtually, I'm here. The Speaker must confirm that it is this person who is a non-registered of this legislator of this House that is voting virtually. The Speaker goes further to confirm that you are actually properly dressed in a parliamentary way. So it's not that automatic that you'll be allowed to vote even virtually. How then would a letter suffice? This motion, Honorable Senators, cannot be allowed to proceed to the next level. Doing so would be to legitimize a process that is fraud, a process that is meant to thwart the will of the people through their elected representatives. And luckily, honorable senators, this is not the first time this is happening. I was here months ago. My learned friend, Katwa Kigen, was here representing the governor. The same arguments I'm raising are the same arguments he raised, Kericho 1 and Kericho 2. And he succeeded. And that's why I have crossed the floor. I am surprised that my learned friend is on the other side. I do not know what he'll be telling you. When the very submissions he raised are the very submissions I'm raising today. Honorable senators, you do not need to call witnesses. My learned friend Katwa Kigen brought 18 witnesses here in the Kericho matter. How cumbersome was it? That thing ought to have been ended at the preliminary. I dare submit. Do the same today. You did it in Kericho 1, you did it in Isiolo. These are not proceedings that can be allowed to go to the next level. The other issue, because of time, let me just raise it, because I only have 3 minutes. Honorable senators, should this motion then proceed to the next level, we have made an application through a letter that we have forwarded to the Senate, calling for the Speaker of the County Assembly, and this letter is the one dated 2nd December 2025, which makes an application to have the Speaker of the County Assembly and the Clerk of the County Assembly to be summoned to appear before you and produce the original letters that are purportedly given to the Speaker, allowing for proxy voting. I say I have 3 minutes. I want to spare them for the rejoinder. My humble submission to you, honorable senators, we could be done before lunch hour today, because there is nothing that is before you. What you have is a stillborn child. What you have is a lifeless motion that cannot be entertained. Honorable senators, unless you have any questions for me, I beg to submit that these senators have other crucial businesses to attend to other than attending to a stillbirth motion. Thank you. I rest my case.
Counsel for the County Assembly, your 20 minutes.